Good evening and welcome to this public hearing of the Standing Committee on Social Development. My name is Jane Wayellen Armstrong. I am the MLA for Mofi-Cleacher Region and Chair of the Standing Committee. At this time, I will ask members to introduce themselves, starting with the one here in the room.
Good evening. I'm MLA Shauna Morgan, MLA for Yellowknife North.
And to those online.
Good evening. My name is Cheryl Yakalaya. I am the member for the Det'anchogh. Thank you.
Good evening. My name is Kieran Testart. I'm the member for Range Lake. I apologize for not being able to be there in person. I have childcare obligations this evening.
Good evening, Julian Morse, MLA for Frame Lake. Thank you.
Okay. Thank you, committee members. Bill 34, Trespass to Property Act, received second reading in the Legislative Assembly on October 31st, 2025. Bill 34 proposes to address gaps in trespassing law by creating a new law intended to govern trespass to private property, to schools, and to certain types of private interests on public lands, such as leases. This committee has been tasked with reviewing the bill to see if it needs any changes. If it has any issues we can solve, and if it is ready to continue on its path to becoming a law. That is our role in this process. We did not write the bill, but we are in charge with taking a very close look at it and making sure this bill represents the wants and needs of residents as best we can. This evening, committee will hear from the Honourable Minister of Justice. Following that, committee will hear from the RCMP Division's Criminal Operations Officer Superintendent Chris Romanchuk. After that, we will open the floor to any members of the public here today who wish to share their feedback on Bill 34 with committee. At this time, I would like to turn the floor to the sponsor of Bill 34, the Honourable Minister of Justice. Please proceed with your remarks and your presentation. Thank you.
Thank you, Madam Chair. Excuse me. Good evening, colleagues. Thank you for inviting me today to speak about Bill 34, Trespass to Property Act. The purpose of the proposed act is to create a legislative framework that governs trespass to private property, to schools, and to certain types of private interests on public lands, such as leases. The legislation will create a trespass offense as well as set out certain exemptions and defenses to trespass, forms of giving notice, arrest provisions, and sentences for violations. The current approach to trespass under a mix of common law and the criminal code creates a significant gap that does not provide timely tools to property owners and lawful occupiers to immediately address instances of trespass that occur outside of the narrow criminal code definition that prohibits a person from entering property at night and near a dwelling house. The proposed bill includes significant safeguards for Indigenous rights, including explicit recognition of Indigenous and treaty rights, ensuring Indigenous and treaty rights take precedence in the event of conflict, and requiring that the Act be carried out in accordance with any applicable agreements. Public engagement indicated significant support for the legislation. This concludes my opening remarks, and we will now provide a presentation walking through the bill in more detail. Thank you. Tonight with me, Madam Chair, I have Brad Patzer, Assistant Deputy Minister, Attorney General, Department of Justice, and Clayton Lowther, Legislative Drafter, Department of Justice, is with us online. Thank you, Madam Chair.
Thank you, Mr. Pratzer. Please proceed with your presentation.
Thank you, Madam Chair. Good evening. Thank you for having us, and I'm pleased to be here this evening to provide a briefing on Bill 34, the proposed new Trespass to Property Act for the Northwest Territories. I'll be providing a brief overview of the purpose of this type of legislation, some information on steps taken during the development of the bill, as well as a summary of the key aspects contained within Bill 34 itself. The Government of the Northwest Territories has introduced a Trespass to Property Act. The Act will create a territorial law governing trespassing, which is the illegal act of entering or staying on someone else's property without permission. Preventing trespassing is important for protecting property rights and maintaining civil order. Trespassers can cause damage, and sometimes trespass is a prelude to other criminal activity, which trespassing laws can help prevent in advance. Trespassing is regulated by a mix of federal, provincial, and territorial laws that govern different cases and land types. The Northwest Territories and other territories lack acts governing trespassing on general private property, which this act is seeking to resolve in the Northwest Territories. While this act is primarily directed at creating an offense for trespassing, we've also ensured that lawful occupiers can get easier access to compensation for when trespassers cause damage. Of course, people may need to access property for legitimate reasons, or may wish to ban entry for some reasons, but allow entry for other reasons. This legislation will ensure that is addressed, and will also ensure that Indigenous rights to govern their own lands are protected. The development of trespassing legislation is important, as it fills a critical promise made to Northwest Territories residents to address public safety concerns. The development of Bill 34. Work towards the development of trespassing legislation began during the 20th Legislative Assembly. The Department of Justice undertook a jurisdictional review of trespassing legislation in other provinces to develop an understanding of the nuances of this type of legislation. We also needed to consider elements unique to the territories, which was made more difficult by the fact that we are the first territory to consider this type of legislation. The department undertook public engagement from September 24th to October 8th, 2025. Residents were invited to share their feedback through an online survey with an option for a written submission at the end. The department also engaged with the RCMP. The department received nearly 700 responses to the public survey. A What We Heard report has been written to provide an overview of the engagement results, and it'll be released shortly. The report shows overwhelming support among NWT residents for developing this legislation. The department incorporated feedback into the proposed legislation where it was reasonable to do so. The department also consulted further on specific points of the draft legislation with the RCMP. Now, getting into the legislation itself, Bill 34 deals with 6 core aspects. We'll go through each of these categories point by point, and you'll likely notice as we go through that some of these have overlapping issues as between the different points. As with most pieces of legislation, we start out in this bill with multiple definitions. The first is the definition of land. We have used the definition of land that we use under the Land Titles Act. It ensures that we are capturing all relevant types of land and tying them to how we define land in the Northwest Territories. Second, we have a definition of premises. This includes land, but also includes different parts of properties, just to make sure we have a very clear and broad definition. The third important definition is of member, as a member of the RCMP. Note that while we have used member instead of peace officer, in practice, these would have the same effect due to how peace officer is defined in the already existing Summary Conviction Procedures Act. The most important definition in the legislation is that of occupier. This is what we mean when we refer to a lawful occupier. It is someone who has physical possession of the premises or who has responsibility and control over the condition of the premises or activities on the premises or control over persons allowed to access it. This means that a landlord, a renter, a store owner, or a security guard would all be considered occupiers. An owner under the Land Titles Act is always considered an occupier under the legislation. Finally, education bodies are defined as occupiers to ensure that the legislation will also apply to public schools. Private schools are already protected under the definition of occupier without the need for a separate definition. The Trespass to Property Bill does not and will not impact Indigenous rights. A consultation assessment was undertaken to confirm that there is no duty to consult regarding Section 35 of the Constitution Act 1982. Indigenous rights are explicitly protected under Section 2 of the bill. The Act is also to be interpreted in a manner consistent with all existing Indigenous rights. Any action under the Act must be carried out in accordance with any applicable agreements, and in the event of any conflict or inconsistency, the Land, Resources, and Self-Government Agreement will prevail over this Act. The law is a law of general application. That means it will apply everywhere in the territory as a rule. However, some Indigenous governments have negotiated the right to establish their own trespass legislation on their own lands. If they did so, that law would apply to their lands. This law in no way prevents their ability to do that. The trespass offense contains a few different aspects. A person is trespassing if they enter a premise when entry is prohibited under the Act, such as when it is prohibited by a no trespassing sign. They are also trespassing if they engage in an activity on the premises when the activity is prohibited. For example, if a sign posted by a lawful occupier says skiing prohibited and hockey allowed, a person who is skiing on the property would be trespassing, but not the person playing hockey. There will be more details about these scenarios in the methods for giving notice section below. A person is trespassing if they stay on a property after being directed to leave by the occupier or a person authorized by the occupier. For example, a person can enter a store normally, but would have to leave if the owner tells them to leave. However, a person is not trespassing if they have the express permission of the occupier. The burden of proof is on them to show that they do have permission. For example, if a person has a text message or a letter from a property owner saying that they can enter the property, they are not trespassing. Likewise, a person is not trespassing if they have a right or authority conferred by law. If a renter has a valid contract from a landlord, they are not trespassing on the location in the rental contract. There may also be circumstances where someone is required to do something on the property by another law. In that case, they would also have a right or authority to enter the property under that law. The offense and note on access. There's a presumption in favor of access for a lawful purpose to a door of a building by means of apparently provided and used for access. This is essentially a presumption in favor of people being able to walk up to a front path or a driveway and knock on the door. It is important that we have some kind of presumption or exemption here. It's typical in society to knock on a door for legal purposes, like saying hello to a neighbor, delivering a package, or visiting a constituent. We don't want these positive activities to be accidentally caught in the legislation. Methods for giving notice under the legislation. There are a few different methods for giving notice that someone can't access your property. The first is orally or verbally. You can just tell someone that they're not allowed on your property. The primary method of giving notice that someone isn't allowed to access your property is, in most cases, is going to be by way of a sign. The sign must be clearly visible in normal daylight conditions from the approach to an ordinary point of access. It can't be hidden or obscured. It can't be in the form of a picture, such as a crossed-out representation of a banned activity. The sign can be a general no trespassing sign, which would prevent all unauthorized people from entering the property. It could also be activity-based, preventing some activities, which would mean all others are allowed, or allowing some activities, which would mean all others are not allowed. Some properties don't require any notice at all. These include land that is enclosed in a manner that's intended to keep people off property, or animals on the property, or any land under cultivation, including a field or a lawn. The legislation allows for a prescribed marking system. No marking system has been planned yet, as this would require additional thought and consultation by the department. Arrest. The RCMP are allowed to arrest someone they catch on the premises without having to get a warrant. They are also allowed to arrest someone who has violated the act and has recently left the premises if that person refuses to give their name and address, or if they are reasonably believed not to be telling the truth about either. A note on citizens' arrests. Citizens' arrests were asked about in the public engagement. The public was overwhelmingly in favor of a citizen's arrest option for trespassing when the trespasser is caught in the act. There is precedent for these provisions in other jurisdictions, which generally allow for individuals to detain or arrest people on their property and deliver them to the police as soon as possible, who are then deemed to have arrested the offender. There were some concerns raised with the provision. The first was that it introduced potential liability for lawful occupiers and may require some level of guidance for lawful occupiers to ensure they aren't accidentally violating the law. This could be in the form of criminal or civil liability for, by way of example, use of excessive force. The second was that there are small and remote communities without immediate access to police, meaning that a person conducting the arrest may not be able to deliver the person into police custody in a timely fashion. The third is that there is a chance we would need to develop some legislation around the use of force in these types of arrest. There are also some potential interactions with other laws like Section 35 of the Criminal Code, which allows for reasonable acts to remove a person from a property or preventing their access to a property. The department notes the overwhelming public sentiment on this issue and is not opposed to including the provision in the future, but would require additional time to consider the full implications. Damages and prosecution. The court can order damages in a trespass matter. The prosecutor must first request damages, and the person who suffered the damages must first consent. Damages are distinct from fines under the Act. Fines are payable to the court. A person who suffered damages is still able to bring a civil action for damages outside of the prosecution. In private prosecutions, costs can also be awarded against the trespasser. Safeguards. The public engagement brought up certain concerns such as discrimination and how this legislation would impact people experiencing housing insecurity and homelessness. The Human Rights Act protects NWT residents from discrimination on protected grounds, including race, nationality, political belief, ancestry, sex, and gender identity or expression. The Human Rights Act is clear that no person shall deny service or access to accommodation or facilities customarily available to the public or employment or tenancies based on a protected ground. It is also illegal to post a sign that expresses or implies discrimination against someone based on a protected ground. This means that anyone who tries to misuse the Trespass to Property Act provisions, such as if they posted a sign or asked someone to leave based on a protected ground, they would be in violation of the Human Rights Act. The proposed Trespass Act should not impact persons experiencing homelessness unless they enter a private property of another individual without permission. For example, for an encampment in Yellowknife established on Commissioner's land, it's that land that falls under the Commissioner's Lands Act, which has its own use and occupancy provisions, and the provisions under that act would apply. The Trespass to Property Act is meant to protect lawful occupiers against their private property being entered onto or misused by others. The penalties under the legislation are a maximum fine of $10,000 and a term of imprisonment up to 6 months. These penalties were arrived at after considering other jurisdictions and other NWT laws. These are maximums. Judges would be able to issue a lower fine and a lower term of imprisonment based on the circumstances. They would be able to do a combination of fine and imprisonment or give either a fine or a term of imprisonment. The public overwhelmingly preferred to have jail as an option during the engagement. It is important to note that the fine is separate from the damages. A trespasser may be ordered to pay fine and to pay damages. Finally, the regulations. There is the power to make regulations under this Act. The Minister can prescribe locations where the Act does not apply. The Minister can also prescribe a marking system, as previously noted. There's also a general regulatory power allowing the Minister to make necessary or advisable regulations under the Act. This concludes our overview of Bill 34. We'll be pleased to answer any questions that the members may have. Thank you.
Okay. Thank you, Minister. Committee, are there any questions? MLA Morgan?
Give me a sec here. Okay. Thanks very much to the Minister and your staff for working on this. So I'm going to start with some questions around who has the powers of arrest. I know you explained why you're hesitant or need to do more investigation before you would allow, say, citizens arrest. Did you consider or see any benefit in allowing, for example, private security company representatives? We do have a lot more it's more common now, at least in regional centers, to have private security companies around various buildings or housing complexes. Or, for example, municipal enforcement officers. Did you consider or see any benefit in allowing those kind of people to have powers of arrest? Thank you, Madam Chair.
Okay, Mr. Pratzer?
Thank you. I think the only thing that was considered in terms of arrest was either the RCMP or police conduct the arrest, because they're the individuals who are trained in conducting arrests. They're trained in de-escalating certain events, whereas all of those others, security guards, I'm not sure about bylaw officers and citizens, would be, I think, more equivalent to each other in terms of their training and their ability to conduct an arrest. So I don't think they are considered distinct from a citizen's arrest. They are all considered as part of a package separate from the RCMP.
Okay. Thank you. I do apologize. I was supposed to address it to Minister Burgers, but Ms. MLA Morgan, do you have a follow-up question?
Sure. Well, I'll ask a different question here. So some jurisdictions allow the court to order someone who was already convicted of trespassing to stay away from that property for a certain amount of time, for example, 6 months. Was that type of provision considered? Thank you, Madam Chair.
Thank you. Minister?
I will pass the question to Assistant Deputy
Mr.
Minister.
Patzer?
Thank you. No, I don't believe that type of provision was considered. We primarily concentrated on the offenses and the fines and the imprisonment in the legislation.
Okay. Thank you. Now we'll go to MLA to start, and then we'll go, do you have a second set of questions? Okay, we'll do it for second round then. We'll go to MLA to start. Thank you.
Thank you, Madam Chair, and thank you to the minister and his staff for the presentation. I also want to zero in on the citizens arrest issue. I have a concern that we may in fact be legislating a tool that will not be effective because it is bespoke to the RCMP. We already have an issue of the RCMP having a lot to do, and they do a lot to keep our communities safe. And this is already a challenge for them to kind of enforce intoxication and things like that when these issues are arising. And now we're going to be asking them to do Trespass Act enforcing as well. So my first question is, are you aware that private security guards in the Northwest Territories are currently undertaking citizens arrests as we speak? Thank you, Madam Chair.
Thank you. Minister?
Thank you, Madam Chair. I will pass to Assistant Deputy Minister Patzer.
Mr. Patzer?
No, I'm not aware. I know there is a provision under the criminal code that allows citizens arrest in some circumstances, but I wasn't aware that arrests were being conducted by security guards. Thank you.
Okay. MLA Tester, do you have a follow-up question?
I do. Yes. So that is in fact the case. These in collaboration, or at least with notice provided to the RCMP, at least in the case of one of the security providers, they are regulated through. They're based in Alberta, so they follow those regulations, and they follow those regulations through their operations in the Northwest Territories. That being said, the issue of training, ensuring there's proper training in place, well, that is the case. And I think you'd be surprised as well to know that many of the security companies do have proper training in place, because if they are regulated in another jurisdiction, that training is required, which would include powers of arrest under citizens arrest. And this is why I think we need to consider this with this legislation, because if the goal here is to have this as a tool, to keep people, to enhance public safety and allow people to better protect their property, then we need something like this, because again, you're going to be putting all the burden onto the RCMP to enforce this new legislation. And as I said, the policing resources are already stretched dealing with guns and gangs, and the drug trade, which is the most pressing concern, of course. So would you consider amendments to the legislation to bring in a section that would allow for citizens arrest provisions like we see in Alberta, Saskatchewan, Ontario, et cetera? Thank you.
Okay, thank you. Minister?
Yeah. Thank you, Madam Chair, and thank you for the question. I'll make a couple of comments and then I'll pass to the Assistant Deputy Minister, but I think one of the concerns that was raised in the presentation regarding the citizens arrest was we have 13 communities in the Northwest Territories that don't have RCMP detachments, and part of the challenge with the citizens arrest is if that was to happen in a small community that does not have an RCMP detachment, is there could be an extended period of time where one citizen is detaining another citizen and not able to follow through on that process in a timely manner. And right now, as I understand it, there's not a consistent requirement within the NWT for the training that may be required for the security industry, if you will, to perform that function. So I'll leave my comments at that and pass to Assistant Deputy Minister to add any additional detail.
Okay. Mr. Patzer?
No, I don't have anything else to add to the minister's response, other than to say that in the presentation, we did indicate that at some point in the future, if we're prepared, the department, would consider these types of provisions. But I think some of the questions that the minister has raised would need to be addressed as well.
Thank you. Ms. MLA Yakalaya, do you have a question?
Yes, thank you. Thank you for the presentation. My question is the minister concerned that the act would overwhelm correctional centers? Thank you.
Minister?
Thank you, Madam Chair. When we initially proposed the three pieces of public safety legislation, I think part of our approach was looking at additional tools to help support the RCMP in some of the challenges with the drug trade and the criminal activity that's currently going on within our territory and in our communities. And I think this piece of legislation will support the RCMP's ability to have an additional tool that they can use in that fight against crime. And I don't believe that we should not enact this piece of legislation because it may increase the amount of people that are, engaged in the system if they are engaging in this type of behavior. So I would to the question, I would say I am not concerned of that at this time. Thank you, Madam Chair.
Thank you. MLA Yakalaya, do you have a follow-up question?
Yes, I do. On RCMP law enforcement, what strategies will be implemented to help relieve pressures on the RCMP with potential increases in calls regarding trespassing? Thank you.
Minister?
Thank you, Madam Chair. I will pass that question to
Mr.
Assistant Deputy
Patzer?
Minister Patzer.
Thank you, Minister. I think as part of the suite of public safety legislation, to the extent this might increase the calls to the RCMP, I think we can expect that, and that's probably what the public is hoping for in terms of alleviating some of the activities that these pieces of legislation are trying to address. Thank you.
Thank you. MLA Morse, do you have a question?
I do have one, yeah. It's kind of an interesting one. I'm not sure if it's for the RCMP or the minister, but I'm wondering about people who have trespassing signs on property they don't own. So does the act in any way consider trespassing signs which don't actually apply? Because I'm just thinking of a couple different areas that I've accessed in the NWT where, you know, for example, somebody's squatting on a road and they put up a big sign saying no trespassing here, or there's a couple other places where I've accessed roads where there's no trespassing signs, and I've always kind of thought, I don't think that they can actually put a sign here saying no trespassing because I don't think this is actually a property. But I'm just curious if the minister considered or the department considered that at all. Like people just, you know, there being new legislation here, maybe people will be kind of, will the act consider in any way people who are putting up frivolous no trespassing signs when they don't actually have any authority over an area? Thanks.
Thank you. Sorry, Minister?
Thank you, Madam Chair. So, yeah, I don't think that we have given that specific question consideration at this time, but I think it's a valid point to raise and certainly something that will need some further investigation. Thank you, Madam Chair.
Okay. Mr. Patzer?
I guess the only thing I could say is that the Trespass Act wouldn't provide any authority for a non-occupier or a non-landowner to place that no trespassing sign there in the first place, such that it wouldn't create a trespassing offense under this piece of legislation.
Thank you. MLA Morse, do you have a follow-up question?
Yeah, I guess I would just ask, like, I mean, I guess it's just something that I haven't considered in the past because we didn't have a Trespass Act, and so there was no worry. But like, I guess I would be more worried now about a sign and whether or not it's frivolous. I'm just wondering, like, who would someone check in with to find out if, you know, does this person own this property? I guess it would be the municipality. Yeah, just kind of wondering about that, how people can be certain, because I mean, the way I read the act, you know, you're committing, if a person claims that they don't want you there, if you ignore a sign, you could be immediately charged with trespassing, but it can be a little bit hard to tell if the sign is put there legitimately or not. So I'm just wondering if we've thought through how people would go about determining that. So I know it seems like a funny question, but I know that I can think of signs in and around Yellowknife that may or may not actually be legitimate in terms of whether they own the land. So that's why the question came up for me.
Okay. Thank you. Minister?
Yeah, thank you, Madam Chair. And yeah, I agree. It's a interesting, certainly an interesting question, and I think whether I'm really struggling for an answer on this one. I'm sorry. You know, I think it's certainly something, and I think in the as we contemplate the ways to provide the signage moving forward, perhaps there is something within that development of that piece that could address this. But yeah, I don't know if Assistant Deputy Minister Patzer has anything to add, but it's a valid question. Thank you, Madam Chair.
Mr. Patzer?
It's complete speculation on, of course, the circumstances behind MLA Morse's circumstances, but I mean, whether the individual is an unauthorized occupier of somebody's property, of course, is a question, and I think the circumstances behind every situation would have to be looked at to determine whether the Trespass Act or whether we need a different tool in the circumstances.
Okay.
Thank you.
Okay, okay, I do have a question too myself. Okay, with reference to what MLA Morris said, the trespassers on Highway 3 from here to from here to Det'anchogh, within the WIC-AG, that's Cleacho land. So it's got to be Cleacho citizens. I know that the houses or the camps that along on the Highway 3, they are registered, and they are registered. So they're. But if it was somebody else, I mean, it's got to be Cleacho citizens. So if it's with somebody else, then I know we haven't heard anything to date that there's other people squatting on our land within the WIC-AG. But I'm just wondering, and we do have, okay, we have that community access, and we have the WIC-AG, and we have the MOFI. So that's the last one. And then, so if anybody was on, within the MOFI, Goga Denitle, means within the MOFI boundary. So if there was somebody there, will that be, without our permission, without Cleacho government permission, will that be considered trespass? Or who would have, I mean, I know that you said in here that you don't infringe on indigenous and the indigenous law will prevail, but, and I believe Cleacho government probably have their own clause within their agreement. So I'm just asking because I'm sure there's going to be more questions like this coming up. I want to ask if the Department of Justice were in contact with Cleacho government on this. Thank you. Minister?
Thank you, Madam Chair. I will pass to Assistant Deputy Minister Patzer for a response.
Thank you, Madam Chair. I can provide some very general comments because I'm not intimately familiar with the Cleacho agreement and the different areas that you have discussed. But the intent of the legislation is to allow private landowners to post and give notice of a trespass on the property. And for Indigenous governments, they could also pass their own laws in relation to trespass. And of course, those laws would apply. So to the extent that Cleacho government has that authority, they could also fill that authority. But in theory, depending on a variety of circumstances, if it is considered private land, this is a law of general application. It could post notice of no trespassing, and if there are people who do not have authorization to be there, it may apply. I know Clayton, our legislative drafter, Clayton Lothar, is also on the line. I don't know whether Clayton has any other thoughts to add to that question.
Clayton, Mr. Clayton?
Yes. Yeah, unfortunately, it is a little bit difficult to say without knowing the specifics, but yes, if they were the lawful occupier of the land, they would be entitled under this act to post no trespass, and then anybody who was on that land in violation of that notice would then be trespassing. But I'm also not intimately familiar with all of the terms of the Cleacho agreement, so I wouldn't be able to definitively say.
Yeah. Well, one of the questions that I asked was that if you were in contact or were you with Cleacho government working on this Bill 34, did they, was there any communications or did that department consulted the Cleacho government regarding Bill 34? But besides that, I have another question, so maybe you can, because I gave 2 to all the other members, so I need to be respectful of that. So in here, the department spoke about the balance between private property rights and resources and compassion for people experiencing homelessness. Can the minister or the department speak more to this balance? Thank you.
Thank you, Madam Chair. So the intent of the bill was not to impact, so the the act that governs commissioner's land, for example, would still apply. So if a homeless encampment was set up on commissioner's land, like has happened within the city boundaries in the past, that would not be considered trespass because the right for citizens in the territory to occupy commissioner's land is covered under the other act. Now, an example that we had used was that, so if someone that was doing that took and plugged an extension cord into a building and was getting power from that building without the owner's permission, that would be an act of trespass, but not the act of occupying commissioner's land. If that answers the question. Thank you, Madam Chair.
Okay, thank you. Okay, we'll go on to second set of questions. So we'll start with MLA Morgan.
Thank you, Madam Chair. So in the in the plain language summary, it explains that Bill 34 establishes penalties for trespassing, including fines of up to $10,000 and up to 6 months imprisonment. Now, I don't see anything specific in the bill that would specify when someone would get a fine or when someone would go to jail, unless I missed it. So how is it established what the penalty actually is in each particular case and whether it involves a jail sentence? Is that solely the discretion of a judge, or is there anything in the bill to guide how serious the penalty or the fine would be, and when it would involve jail? Thank you, Madam Chair.
Thank you. Minister?
Thank you, Madam Chair. So the penalty imposed would be up to, it would be at the discretion of the court. Thank you, Madam Chair.
Okay. MLA Morgan, do you have a follow-up question?
Yeah, thank you, Madam Chair. And I might not get the right terminology for this, but I'll try to explain the concept I'm thinking of. So my understanding is that some jurisdictions would provide details to specify that, like, a first offense would be treated differently from a second or subsequent offenses if trespassing occurs on the same premises by the same person. I'm assuming that, like, the penalties would be specified that they should increase or, with second or subsequent offenses. I don't think that is written into this bill. So did the department have a particular rationale for omitting consideration of sort of first offense versus subsequent offenses in terms of what penalties should be applied? Thank you, Madam Chair.
Minister?
Thank you, Madam Chair. I will pass to Assistant Deputy Minister Patzer for a response. Thank you, Madam Chair.
Mr. Patzer?
Thank you. So typically what happens in sentencing is that if it's a first offense, the court would have a notice or would know from looking at the individual's record that it was a first offense, and they probably wouldn't have the full maximum penalties imposed upon them as a fine or imprisonment or one or the other. But if there was a second or third or fourth offense during the sentencing process, the court would be aware that this individual continues to be convicted under this legislation, and the fines would continue, or and the imprisonment would, the risk of increase would increase as each offense was committed and convicted was followed through, and the sentencing that would follow would be continuing to escalate until it hit the maximum, of course, and the court doesn't have the authority to go beyond the maximum.
Okay, thank you. MLA Morgan? Okay. MLA Testart, do you have a question?
Yes, thank you, Madam Chair. So following up on my last question, one of the, I guess the rationales was the lack of capacity in some, for not including citizens arrest provisions, the lack of capacity in 13 communities with no accessible or easy access to the RCMP and bylaw. Would it be possible to craft regulations or somehow modify a section for citizens arrest to accommodate those realities? Because I think this legislation is useful everywhere, of course, but where we are seeing the most acute examples of its need are in the larger centers that are resourced. And it seems like we should be able to find creative ways to build a legislative regime that would allow those larger centers that are fortunate enough to have policing resources to use them effectively. Is that something the department will consider? Thank you, Madam Chair.
Thank you. Minister?
Thank you, Madam Chair, and thank you for the question. As we had stated previously, looking at this, it's not necessarily off the table. There is opportunity to look at this as we move forward in the development of the bill, but it's not something that we've had a considerable look at right now, and this would require, additional time for us to understand the implications of going this route. But like I said, there's always an opportunity to look at this and see what could possibly work and it may be able to be set out in a way that could apply, not necessarily to all communities in the same way. But this investigation would take some time. Thank you, Madam Chair.
Okay. Thank you. MLA Tester, do you have a follow-up question?
Yes. Did the department, Madam Chair, did the department consult with the RCMP on this issue? And what was the understanding at the time when the legislature, did the RCMP raise this as a concern that it would require a greater capacity from their policing resources to meet the additional demands of the legislation? I'm just trying, I'll ask that question to the RCMP directly, but from the department's understanding, was that asked, and what was the response? Thank you.
Thank you. Minister?
My apologies, Madam Chair, and thank you for the question. That specific question around capacity was not directly asked of the RCMP. However, they are already fielding these types of calls in their day-to-day activity across the territory. So it is something that this would be, again, the tool that would be put in place to support that activity in a more meaningful way. Thank you, Madam Chair.
Thank you. MLA Yakalaya, do you have a question?
Yes, I do. I'm going to ask about equity lease to own. Is it owned by homeowner or GNWT for land, for property, for reasons of trespassing? Thank you.
Okay. Thank you. Thank you. Minister?
Thank you, Madam Chair. Yes, a leaseholder would be considered an occupier/owner of the property and be able to use the Trespass Act on that property. Thank you, Madam Chair.
Thank you. MLA Yakalaya, do you have a follow-up question?
Yes, I do. In some jurisdictions, in some jurisdictions, trespass legislations allows the court to order someone who was convicted of trespassing to stay away from that property for up to 6 months. Does the minister foresee a benefit to including this type of provisions in Bill 34? Thank you.
Thank you. Minister?
Thank you, Madam Chair. Madam Chair, that provision was not considered in the development of this piece of, in this act. Thank you, Madam Chair.
Thank you. MLA Yakalaya, do you have a follow-up question?
Sorry, Madam, I asked 2 questions already.
Okay, then. Is there any more other questions from members? Okay.
Madam Chair, I'll just ask, maybe if I can just ask, why wasn't it, why was it not considered? Thank you.
Okay. Minister?
Thank you, Madam Chair. Madam Chair, I could possibly pass this question to Mr. Louder. I don't have that specific information. Thank you, Madam Chair.
Okay. Mr. Lauder?
Thank you, Madam Chair. I don't recall this specific idea arising when we were looking into the background and examining other jurisdictions and what they had in terms of options following a sentencing for somebody who's been convicted of a trespass offense. I would note that our Summary Convictions Procedures Act incorporates provisions of the criminal code, and there may be some provisions under the criminal code that would allow for similar things to occur, but that kind of standalone provision wasn't considered or identified as a potential inclusion under this Trespass Act.
Thank you. We'll go to MLA Morris.
Thank you, Madam Chair. I do want to just, I'm just trying to explore kind of some what ifs because, you know, I'm just thinking through scenarios that could occur here. And, you know, I want to raise just a couple that are occurring to me as I consider this. I think the thing that's worrying me just a little bit is that someone can simply throw up a trespassing sign, and anybody who sees that sign is considered to have been given notice. So a couple scenarios I want to raise here, and I would imagine there's a lot of this across the territory. You know, just areas where public trails technically fall on private land in some areas. Like something that Yellowknifers might be interested to know is a good portion of the Tin Can Hill trails are actually on a private mining lease. And technically, you could just throw up a trespassing sign, and it's not just a matter of, well, we were on the trail walking our dogs, and it's a totally benign activity that has now technically become illegal. And so I'm just a little bit worried about the idea that, like, I mean, has this been seen in any other jurisdictions where people like dog walkers are suddenly getting charged with trespassing and things like that, where, you know, people are just using an old trail that's been in town forever? You know, it's just, this will suddenly be technically an offense. And I'm sure that the RCMP can provide a bit of comfort that they're not going to go around charging every person that walks a dog on Tin Can Hill, but it does kind of raise a bit of a concern for me. Like, do we need to have a certain amount of provision there for reasonable warning or reasonable activities? I know some places, you know, I've heard through hearsay that Norway provides access to private lands for all citizens for camping and hiking and things like that. And I'm just wondering, you know, if you're simply passing through, is that a bit different than kind of nefariously occupying the land? Like, they're really different activities. And yeah, there's areas in my community where it is technically on private land, but no one's causing any harm. And, you know, if someone happened to throw up a sign, it's an offense. So can the minister discuss whether they've thought that through?
Okay. Minister?
Thank you, Madam Chair. And I think this part of the thought process was that, like, when the penalty regime was set up, there's no mandatory minimum, like there's no automatic first offense fine that's related to this. So I think from that regard, I mean, I would like to think that common sense would be also part of this process. But I will pass to Assistant Deputy Minister Patzer to provide some additional details. Thank you, Madam Chair.
Thank you. Mr. Patzer?
Thank you, Madam Chair. Just to follow through on the example that MLA Morris provided, where somebody threw up a sign on somebody else's land, I think it's important to understand that the Trespass Act, as it's currently drafted, only provides occupiers and owners with the authority to impose no trespassing. So if somebody, a third party, is putting up a sign on somebody else's land, that doesn't create any authority for, under the Trespass Act, to have somebody charged. So presumably, if I'm walking on Tin Can Hill and there's no trespassing sign, whoever arrests me, the RCMP arrests me, they're going to have to prove that an owner put up the no trespassing sign. I don't know who owns Tin Can Hill, but if it was a third party that put up the no trespassing sign, that sign has no authority under the trespass legislation as it's currently drafted to provide anybody else, other than the owner the authority to put up the no trespassing sign. So in that case, there shouldn't be any arrests unless it's the owner or occupier who's actually putting up the no trespassing sign. I hope that clarifies things. Thank you. Thank you.
Okay, thank you. MLA Morris, do you have a follow-up question?
Yeah, I do. I guess in this case, I was trying to get at a different issue than the third party one. In this case, I was thinking, you know, I mean, any landowner or leaseholder or somebody who's got an interest in land, it may just simply be easier for them to throw a no trespassing sign up than consider the nuances of things, of public use of things. And I mean, I'm thinking about, you know, lots of people in the NWT access different winter roads that are established by different lessees. And, you know, there's no real problem with that. It's an activity that has been going on in the NWT for a long time, but they may consider, you know, I don't really like the idea of any liability, so I'm throwing up a no trespass sign. And it's gone from something that, you know, people could just ignore to technically an offense because the sign is there. So I'm just wondering about whether we've considered reasonable use and, you know, areas where people don't intend to do anything but just traverse over the land. You know, I'm just there to walk my dog or things like that. And maybe they didn't see a sign. You know, is the fact that the sign is there enough that people have committed an offense, or do they have to have seen the sign? I mean, there's just lots of little nuances here, and I just don't want to be putting citizens in the position of tickets or restriction from areas that they would normally be able to access just because technically it's an offense now. So that's what I was trying to get at, is not even third parties, but what if a person who is a leaseholder just simply decides it's easier for them, that they don't want people passing through? I mean, I suppose technically it's going to be an offense now. So that's kind of where I was getting at, is the reasonableness of applying this law, and whether it's going to apply equally to a dog walker versus a person who's actually really shouldn't be there and is doing something negative, like breaking into my shed or something like that. Because I really think there's a huge distinction between those activities, but the act doesn't make a distinction. So that's what I'm asking about.
Okay, thank you. Minister?
Thank you, Madam Chair. Yeah, I mean, I think it's hard to put that level of, if you want to call it reasonableness, into the act. I mean, every circumstance would have a potential different outcome, and what may be a benign activity for 99% of the population, there still could be 1% of the population that's crossing onto private land. An owner onto land that someone owns is the rightful occupier, with not the intention of the 99% of other people that are crossing that land for a benign reason. So from that context, it would be really hard to create an act that can allow for that type of nuance, I guess, for lack of a better term. Thank you, Madam Chair.
Okay, thank you. Minister and Deputy Minister Patzer, thank you for the presentation. Now we will move on to the next presenter. Superintendent Romanchak. Check.
To the committee members for allowing me the opportunity to speak here today. I am honored to be part of the RCMP to provide the perspective relative to this legislation. And I do appreciate the conversation and the collaboration from the group. So thank you. To start off with, I would like to say that the RCMP, in the spirit of this legislation, are supportive. So this does fulfill a gap in legislation that we do not have here in the Northwest Territories. At the current moment, without this legislation, we can either do nothing or go right to a criminal offense. And a criminal offense obviously is not the most appropriate mechanism to deal with some of these types of behaviors. Additionally to that, when we look at our crime severity index for the Northwest Territories, it's high. It's quite a high number. And when I looked at the breakdown of some of that this afternoon in advance of this meeting, I note that a large number of the offenses captured under this CSI is mischief. And so that would be one of the criminal offenses that we would use when we get these calls for service about trespassing. And if I look at the 7 communities that are listed under the CSI, we have a range of 13 to 39% of the CSI is captured in mischief. That has a direct impact, just from a numbers perspective, on industry, commerce, confidence in people moving into communities from the outside where the Northwest Territories and some of the communities are looking to develop further. So I recognize that while it's not specific to trespass legislation, there is a ripple effect and there is an impact to that. The other item that I would like to share, and certainly piggybacking on some of the questions that were posed to the Honourable Minister and ADM Patzer, is the use of this legislation. From the RCMP perspective, this isn't going to be one that's at the very top of our toolbox. We have lots of tools in the tool belt. We would seek to use a measured approach for this. So if we have people who are walking dogs, for example, that might not be primacy of operations. If we have somebody who is a constant problem, is an epicenter of crime with one of our communities, whether a large one or a smaller one, that could be a tool that we could use to leverage to change the trajectory of that behavior into compliance. So going back to my original comment, the spirit of the legislation, the RCMP are supportive. I note some of the other questions, such as citizens arrest, signs posted, definition of, occupier. One of the items that, the RCMP provided feedback on was relative to the scope of the legislation specific to the RCMP or more broadly to a peace officer. And so it was the RCMP's recommendation that that would move toward a peace officer to provide some broader enforcement capability, potentially when other legislations are supportive of it. So for example, Municipal Enforcement Division or the sheriffs. If I look at other jurisdictions into the south, like the southern provinces, there's a multi-level tiering of enforcement, and not everything is solely to the RCMP. The other comment that I would like to make is that the reality is the RCMP are already receiving these calls for service. So do I see a significant increase in calls? Not necessarily. There may be some peaks and valleys depending on what's going on within the communities and the priorities that are communicated through our membership and our detachments and the community leaders. But I don't anticipate at this time that it's going to be a significant spike. What I do see is another tool to use to manage some of these behaviors that are annoying at the minimum and destructive on the higher end. I would say one of the items that I had not considered during the consultation was the schedule of penalties. So I think that's a good collaborative topic of discussion. As well, I believe one of my concerns, and I apologize for not communicating this in advance because it's something that I had not thought of, is that it appears that this legislation focuses solely on court process. So while the RCMP would be looking to measure the approach, there's no ability, at least that I'm aware of, that we could go and in a first instance, issue a violation ticket. Or in a second instance, issue a violation ticket with a higher amount. At some point, if there's a repetitive behavior, we'd be seeking a court process where the judiciary could make a determination based on the facts presented, if there was a guilty finding, for some form of remediated sentence. That does not appear to be in place, and I believe that's something that we should probably collaborate further on from a consideration perspective. So I think I will stop there, Madam Chair, and if there are any questions posed by yourself or the committee, I'd be happy to take them. Thank you.
Okay. Committee members, do you have any questions? Okay. MLA Yakalaya?
Thank you, and thank you for the brief description from the RCMP. Does the RCMP foresee any challenges affecting their operations if trespass legislation is introduced in the territory? Thank you.
Thank you. Superintendent Romanchuk?
Thank you, Madam Chair. I appreciate the question. From an operational perspective, I don't think that there's going to be challenges insofar as attending and responding to the call for service and identifying the individual who the complaint is made about. I do, after listening to some of the questions that are posed, I wonder about the definition of occupier. And are we going to get into a position from an enforcement side where we're putting in a court package to our friends at the Crown Counsel office, and we need to go through a relatively simplistic piece of legislation to now there are a lot of checks and balances and elements of an offense, and going to land offices and determining proper ownership. Like, there may be a lot of steps to this that complicate the prosecutional side. The investigational side, I believe, is relatively simple. But that would be the only impact that I would see that could potentially be problematic on the operational end. Thank you.
Thank you. MLA Yakalaya, do you have a follow-up question?
Yeah, thank you for that. And that's something that we will have to look into. So I appreciate that. Now, how does the RCMP foresee the new legislation affecting patrol priorities and call volumes? And are current resources sufficient to manage the potential increase in workload in this Trespass Act? Thank you.
Thank you. Superintendent Romanchuk?
Thank you. I actually don't see there being a significant increase for calls to service on this. I believe that we're already fielding those anyway. When people are, in a dwelling house when they're, asked to leave, or if they're in an area that, they ought not to be, the RCMP are getting the calls for service anyway. And I believe that goes to the public trust and confidence that remains ongoing with the communities in our service delivery. Relative to the priorities, each community sets, in collaboration with detachment commanders and the RCMP, what some of those priorities are. And some of those are done through letters of collaboration, which help us identify and hear what the community's feedback is relative to the issues that they're facing. If this legislation is supported and if it becomes enacted in operation, I would like to think that those conversations between the police and the community would remain ongoing. And if that's a priority by the community, then we would respond accordingly. Thank you.
Thank you. MLA Testar, do you have a question?
Yes, thank you, Madam Chair, and thank you for joining us tonight to our witness. My question is, I suppose the enthusiastic support for this legislation from the public that we heard about from the Minister of Justice's presentation is premised on the idea that this legislation is going to result in, I guess, more tougher rules around trespassing and potentially more ability to address those situations. So just hearing what you were saying, that you don't anticipate, or hearing what the witness is saying, that there isn't an anticipation of increased volume of calls and kind of increased volume of work. Is this going to make a kind of appreciable difference in the minds of the public? Like, is the public going to see kind of more enforcement of trespass provisions after this legislation's passed? Because I think when you think of the downtown, as we heard in the presentation, the downtown core apartment buildings in the community I represent, Yellowknife, that's what we want to try to address and clean up. So is that actually going to happen with the passage of the legislation as it's currently written, according to the RCMP's resources and estimation of how those resources are going to be used to implement the act and use it as a tool? Thank you, Madam Chair.
Thank you. Regional Superintendent, RCMP Superintendent Romanchek.
Yeah, thank you for the question, Madam Chair. You know, if I had a magic crystal ball, I'd probably be able to answer that with any amount of accuracy, and unfortunately I don't. You know, what I can say is that our members, you know, certainly here in Yellowknife and our other communities, not only do they respond to calls, but they do proactive patrols as well. We've heard, you know, throughout the summer, certainly there were calls for additional you know, visibility and foot patrols in the downtown core and here in Yellowknife, and to move some of these nefarious individuals or unwanted individuals along. This is a tool that I see that could be very valuable. I guess part of my hesitation, and not in the legislation itself, but, or not in the spirit of it, but is if this is only a court-driven process, then if I think about the life cycle of whether the RCMP walk up to somebody who is in an area where they're not supposed to be, or if there's a call for service, we are left with an enforcement action of arrest and then provide a court compelling document. And so when I think about, you know, some of the transient population across the Northwest Territories and in Yellowknife, are they actually going to show up to court? And if they don't, what's the impact on the courts? So the police are already getting the calls for service, but there's court time that also needs to be scheduled to manage and deal with these things. And if everything is going into the court system, then what is the larger impact that's really happening in those downtown cores? So if we approach somebody, we arrest or detain them, we issue them a court compelling document, the likelihood of us holding somebody on bail over a trespassing violation is probably pretty low, depending on the circumstances of the fact pattern. So we'd be seeking a release, and they would go off. So they could potentially return to another area. And we become involved in a cycle that really isn't hitting the objective of the legislation. Thank you, Madam Chair.
Thank you. MLA Testar, do you have a follow-up question?
Thank you, Madam Chair. Thank you for that response. I acknowledge my question was very speculative, but I think you've cautioned us as to, or the witnesses cautioned us as to, you know, to temper expectations. So, can you give us insight on what kind of changes we could make to the legislation to improve the operational side of the work of the RCMP? Because certainly that's the intention here. It's not to jam up the courts with more process and potentially put vulnerable people who may be causing trouble, but they might not have the means to. Well, anyway, it puts them back in the system again and again and again, and that's not ideal either. We want these issues to be resolved. We want the streets to be safe. We want people's apartment buildings to be safe. So that's my intention, at least. How do we get there? How do we improve the operational side of this so we can make a bigger impact on the streets where we need to improve public safety? Thank you.
Thank you. RCMP Superintendent Reuploaded.
Thank you, Madam Chair. You know, I think I'd be remiss if I just listed off a number of items, because I truly believe that it's been this collaborative environment here in the questions that have identified some of the maybe areas for reconsideration or areas to maybe develop further. And I think I'll just leave my answer at that. Thank you, Madam Chair.
Okay, thank you. Next, I have MLA Morgan, followed by MLA Morse. So MLA Morgan, go ahead.
Thank you, Madam Chair. Definitely food for thought. I mean, when you were speaking about the hypothetical of a person who's sort of transient, perhaps homeless, downtown, say, being issued a document that they have to appear in court, or, being held for a bit, and then them not appearing, what does that mean? I was also picturing an alternative of, we'll just give them a ticket, but then how likely is that person to pay or to be able to pay, and then what have we accomplished? But anyway, those are questions to think about. I wanted to follow up on something you mentioned earlier that could complicate the process. You said more on the prosecution side than the investigation side, around perhaps it being more complicated than hoped to figure out who exactly is the proper occupier, landowner, what authority do they have, how clear was it exactly that this is their land and that someone was, anyway, trespassing. But even on the investigation side, what tools would RCMP members themselves have to distinguish, say, I don't know, like when they're just going and responding to a call or out there on the street, as to whether this is actually private property or it's actually public land or a common area? Like, how do you have like a big database or some easy way that they would know immediately or be able to verify that, in fact, this is private land and not public land, like whether the land in question is covered by the legislation? Thank you, Madam Chair.
Okay, thank you, Superintendent Reuploaded.
Yeah, I would say that in some cases, yes, we would know that, and in some cases, we wouldn't, and we need to do further digging. So we have direct access to driver's license details, as well as license plates, so vehicle ownership. So we could conceivably go to a residence, do some database queries that we have access to, and determine, okay, well, these occupants are, they have that under their driver's license or their license. And, from a reasonable perspective, that would provide some good direction at the beginning of an investigation. There may be other areas that we really don't know. Like if somebody has leased a property to somebody else, and, who has color of right, to some of the responses and questions that were posed earlier, we would need some form of a complainant. And somebody to say, hey, there's a bit of a problem here. And through that investigational process, or through the, eliciting of information, we would ask the complainant, where do you fall in the mix of ownership? As I look at the legislation as it is, as I look at the definition, it says occupier. It doesn't say owner. It doesn't say leasee. And if I think about another alternative that could potentially happen, and if this is really for public safety, and I believe that's the spirit of the legislation, if we had drug dealers that have bullied their way into a residence and now they occupy it, but are they the owner? Are they the leasee? Are they on some form of a document? Likely not. And that, I believe, is where we might have some complications and need to really dig in further, especially if we have people who are being leveraged against their will. At sometimes that does happen. And we have people who are just not contributing to the investigational process. Thank you, Madam Chair.
Thank you. MLA Morgan, do you have a follow-up question?
Thank you, Madam Chair. So it's good at this stage that we're identifying things that we need to think about more and, yeah, more questions to ask, problems to address. I know we're not going to come up with all the answers tonight, but I really appreciate you helping us sort of think through some of these scenarios. I wondered if you could expand upon, you started out by explaining that this would not necessarily dramatically or radically change what the RCMP is doing, because you're already receiving calls and trying to respond to complaints and calls, but it would add something to your toolbox. And so currently, when people are complaining, it sounds like your main recourse, well, either do nothing or charge someone with mischief. Can you explain what difference it makes whether you are charging someone with mischief or you have this new Trespass Act where you would have this other option? Like for sort of lay people, or like what difference does that make? Maybe you can walk us through a bit more why it's significant to you to have this other tool. Thank you, Madam Chair.
Thank you. Superintendent Romanchak?
Yeah, thank you for that question. From my perspective, you know, if somebody goes through the criminal lane, so if they get charged with mischief or some other, you know, charge under the criminal code, and if they're found guilty, they have a criminal record. And through a territorial legislative piece, there's not necessarily a criminal record. And when I think about the people who are looking for work, right? They're trying to get hired, they're trying to make ends meet. You know, sometimes people make poor decisions when they're younger, and as they mature and life circumstances change for them, then they're burdened by some of those previous decisions, including a criminal record, which may preclude them from travel outside of the country, may preclude them from a number of different things. So I think that's one of the larger items of distinction here, is that with the tools that we have now, it's really nothing, or, you know, verbally we ask them to move on and hope for voluntary compliance, or we charge them criminally. And I don't think, if we're looking at a measured approach and we're looking at a continuum of, you know, applicable measures, that's not it. And that's why I believe, you know, the RCMP, in the spirit of this legislation, to fill that gap from the do nothing or verbal compliance to the criminal side, that's where I believe that this is the right fit. Thank you.
Okay, thank you. MLA Morse, do you have a question?
Thank you, Madam Chair. Yeah, no, I appreciated the suggestion about including options for issuing tickets as opposed to court proceedings. I think that's a great suggestion. I can't see the minister right now, but I'm going to assume he's probably going to be amenable to that kind of inclusion, and certainly I'm in favor of something like that. What I wanted to ask as follow-up to that recommendation is, does legislation like this ever give guidance as to severity of offenses? And you know, you heard my previous questions. What I'm really trying to get at is ensuring that this legislation doesn't go over the top in leading to unnecessary convictions for people who are simply walking a dog or something like that, or, somebody who was maybe in good faith, didn't intend to trespass, et cetera. And I think giving options, but I'm wondering, do we need to ensure that the legislation clarifies that there are levels of severity for offenses? I mean, I think there's, as we've talked about this evening, there's different kinds of trespassing. There's, I happen to walk my dog through this property, and I was on this property to steal somebody's car or trailer or something like that. So, where charges do seem appropriate. So I'm curious if we need to ensure that the legislation clarifies that, or is that usually left up to interpretation? If you have any suggestions for us how to make this legislation applicable to the problems we're trying to solve with it, that'd be great. Thanks.
Okay. Thank you. Superintendent Romanchuk.
Thank you. I think I'll start off by saying, I know the example of dog walking in an area where, a sign may be posted and it may be legitimate or it may not be. I'll go back to what I said toward the onset. We would be measuring our approach to this. We're not, we have a lot of demands for service in the communities. And while trespassing is one of them and we're going to respond, there needs to be some form of reasonable discretion that is employed by the police of jurisdiction during the enforcement of a legislation such as this. Secondly, I would say that other jurisdictions, in my experience, depending on the legislation, have been prescriptive as to what first, second, escalating offenses are. That would not be, up to the RCMP to, comment further on as to what those sanctions would potentially look like. We'd leave that over to our legislators over with the government of the Northwest Territories. Thank you.
Okay. Thank you. Mr. MLA Morris, do you have a follow-up question?
Yep. Thank you very much, and I appreciate that answer. That helps clarify things for me as to where we need to go next with things. Actually, my next question, if it's okay, would be for the minister. Is that all right?
No, not at this time.
Thanks, Mrs. Chair, or Madam Chair. Are we going to have an opportunity to ask questions of the minister again, or is that time is done?
Well, check with the minister right now. Minister, would you? Are you open to for the committee members to ask more questions after?
Certainly
when the time permits.
if there's time permitting.
Yeah. Okay. If time permits. Yes, Julian. Emily Morris. Thank you.
Thank you.
Yeah. Okay. I do have a question too as well. Okay. You mentioned about drug dealers and drug busts. In small communities, I know there's a lot of community members. They have issues with drug dealers coming in. And we know that many of the drug dealers in the small communities, we have housing crisis in many of the communities. So some of the drug dealers are living in a private and public unit. Their names are not on the lease, so they're squatting. And I know that in the past, many of the community members, they call the RCMP, but they can't enter because they don't have a warrant, and they want to be specific of where the drugs are located in the dwellings. So do you think this bill will make it easier for the RCMP to come to the residents, even though because people do know, people see it in Betchacon, for example, we'll use Betchacon because a lot of people put it on social media of where the drug dealers lived, and then they do pictures, and then it's a high traffic area. Even where I live, in my, couple houses down from me, there's, it's not the people, but it's the residents, it's a dealer that are, they're taking over other people's house, the vulnerable, especially the vulnerable. So do you think this bill will make it easier for citizens to call and report, and the RCMP will respond? Thank you.
Thank you, Madam Chair. That's a good question. I'll start off my response by saying we recognize and we hear the communities at the senior management level and at the detachment level relative to the issues and the crises that are happening within the communities, specifically around drug trafficking and drug addictions. The government of the Northwest Territories has made some significant contributions. So our Territorial Crime Reduction Unit, which is fully staffed and conducting operations throughout the territory, most recently with some pretty significant disruptions of drugs within the southern district of the RCMP territory. So those actions are ongoing. The other item that I will say, and specific to the latter part of your question about the legislation, is this something that could potentially be used as a tool to gain access to the residents to disrupt that, criminal behavior? I'm going to be candid and say not necessarily. We need to be cautious that we're not using tools that aren't meant, that are looking to circumvent other legislative pieces, and specifically the charter, to get inside a residence to conduct the operations. There are no charter-free zones, within Canada, so we need to make sure that from a policing service delivery, we need to abide by the legislation that's in place. Now, if we have somebody who is in the residence who, is on the lease, and they call the RCMP to say, hey, I've got people who are in here who I want out, yeah, we will certainly respond. It won't be with the intention of, disrupting drug trafficking within a residence, but if we go inside there and we're responding to the call for service and we see what we see, we will respond to that accordingly as well. Thank you.
Okay, thank you. Well, what about if, like some of those, the private homeowners, they're living in a unit or in a house of a late parents and or late grandparents, and the house is not registered to them due to legal issues, due to the estate's issues. Would you consider those people trespassing? Because, it's not legally their house, but they're living in there because of the estate, incomplete estate, and or it's nobody's house. Thank you.
Thank you, Madam Chair. That's a bit more of a complicated question, and certainly one that has a lot of gray area to it, which is likely why you're asking it in the first place. That would take some more lengthier investigation on behalf of the RCMP when they respond to that call for service. When I look at the definition currently under Bill 34, it says occupier, and if there's no prescription relative to home ownership or leasee, then if they've been in there for a certain period of time, potentially they could be seen or defined as an occupier, and that could become problematic, right? Depending on whoever the complainant is and what they're trying to leverage and what their objective is. So there's no clear-cut answer on that, Madam Chairman, but I do see that as something that could cause some head scratching and some further, peeling back of the layers of the onion to see really what's at the core. Thank you.
Okay. Thank you. That's interesting to know because living in the small communities, we do have legal issues with, with the property tax and property lease. So there's lots in small communities that it's like we're a squatter, in many because of the unresolved estate issues. So, I mean, not just, it's in general, there's lots. So it's something that I guess it's being, Department of Justice is working with the community governments. So, but it's good. Thank you. Thank you for your answer. I will go to, we still have time for a couple more questions. We're here until 9. So I will go to MLA Testart, followed by MLA Morse. Thank you.
Thank you, Madam Chair. The witness most likely overheard our discussion around potentially including citizens arrest provisions in legislation, as there are in other jurisdictions. Is there a perspective that the witness can share, the inspector can share on that? Thank you.
Regional Superintendent Romanchuk.
Yeah, thank you. As I think of, like loss prevention officers, those who are in the stores and trying to negate the effects of shoplifting, those items are already happening. And what would happen there is that the loss prevention officer would detain the individual, they would call the RCMP, and the RCMP, would respond and take custody of that individual, potentially issue some court documents. Now, I did hear this discussion, about the smaller communities. You're right, that's a challenge. Geography is not necessarily the friend, and conversely, it's the friend of the Northwest Territories. I think my larger concern with, a citizen arrest is that you don't really know who you're dealing with on the other end. So the police, and potentially the loss prevention officers or the security people who have some training know how to de-escalate and know how to protect themselves where the general citizen may not. And I think the last thing that I would like to see from, policing service provider is that one of our citizens who's trying to do the right thing gets hurt, or if there's some use of force, they find themselves in some sort of civil litigation initiated by the subject of complaint. So I do caution that a little bit. I think there is likely room for a measured approach, and I know I've used that term a few times because there's a continuum, I believe, into what a response could look like. But I would say just a fulsome enactment of kind of citizens arrest for this. I think that may do more harm than good. Thank you.
Thank you. MLA Testart, do you have a follow-up question?
Thank you. Yes, that's very helpful to have that perspective. I share those concerns around individuals. However, I do think that with sufficient training and resources and preferably regulation, security guards, loss prevention officers can play a part in this because the police can't be everywhere, and they're already in place. Would there, I guess, do you have a perspective on that if private security or private security officers were brought into the legislative regime somehow? Like I acknowledge that the challenge of letting anyone do it could bring harm, or it brings risk of kind of harm to yourself, even if you're getting involved doing a citizen's arrest if you're not properly trained. So for those who are properly trained and have, I'm assuming the RCMP has a relationship with many of these security providers. Is there any concern with bringing them into this legislation at all from an operational standpoint? Thank you, Madam Chair.
Thank you. Superintendent Romanchuk.
Yeah, thank you for the question. My answer is, it depends. It depends on what the objective that the government of the Northwest Territories is looking to complete with the legislation. The recommendation, I shared it at the onset, was that from the RCMP was that instead of this being prescriptive to the RCMP, is that it be opened up a little bit more to peace officers. I believe that further exploration and assessment would need to be completed relative to security companies or loss prevention officers and for their ability to, enforce legislation. And I think I'll stop there. Thank you.
Okay, thank you. At this time, I would like to invite Minister Macdonald back to the table for MLA Moore's question.
Thank you.
Thank you. Okay, MLA Morse, you can proceed with your question.
Thank you, Madam Chair, and I appreciate the committee and minister's indulgence. I just wanted to follow up on an answer to a previous question that I think was an important one to get on the public record. And the minister earlier clarified that this act isn't going to apply to commissioner's land, as I understood it, if that's correct. And I expect a lot of people are going to look at an act like this being enacted and expect that this is going to be a new way to manage encampments being established, and many of them are currently, at least in our community, on commissioner's land. And so I just want to ensure we're managing public expectations and certainly being clear with ourselves about what this new legislation is and isn't going to be able to achieve. So if the minister could provide a bit more clarity on that, that would be helpful, or just clarify exactly how the act will apply with regards to commissioner's land. Thanks.
Okay. Thank you. Minister?
Oh, sorry. Thank you, Madam Chair, and thank you for the question. Yeah, happy to clarify that. So currently there's an act that governs commissioner's land in the Northwest Territories, and that's the Commissioner's Land Act. And that act specifically states that residents of the Northwest Territories have access for essentially camping on commissioner's land, and the creation of the Trespass to Property Act would not impact that ability of the Commissioner's Land Act would still be enforced. Thank you, Madam Chair.
Thank you. MLA Morris, do you have a follow-up?
Thank you, Madam Chair. I do. This one may be one that the minister will have to come back on, although you may have an answer off the top of his head. But I'm just wondering, the minister's aware I submitted a request the other day about winter roads specifically. I know there's a lot of areas in the NWT where winter roads are constructed under land leases or other instruments, land use permits. And I'm just wondering, a lot of citizens use those winter roads for harvesting wood or hunting or various other activities that are kind of unrelated to the land use. But I'm just wondering, would the Trespass Act apply to those, or is it going to depend? If the minister could provide clarity to committee either in writing or verbal answer, it would be helpful. Thank you.
Minister?
Thank you, Madam Chair. So yes, within the Act, the Act can apply to land or water. So it could be applied if the leaseholder decided that their road they did not want access to. They could, under the Trespass Act, restrict access to that road. Thank you, Madam Chair.
Thank you. At this time, okay, if there's no more questions then. Seeing no further individuals who wish to speak to Bill 34, committee would like to thank everybody who attended today's public hearing. The feedback we received today will be considered by this committee in our review of Bill 34. And I want to say thank you to the RCMP for coming. I want to say thank you to the RCMP for the good work that they are doing in NWT, especially with drug bust. And I know that people, really do appreciate, especially the parents and the grandparents in small communities, which is a major issue in many of our small communities. And because I see this on, on social media, when there's a drug bust, people do appreciate. They said, good work, so it's evident, it's out there. So I just want to say thank you for the good work that the RCMP are doing, keeping our community safe. So thank you for coming, and thank you for coming, Minister Macdonald and Deputy Minister Patzer. Thank you. So this concludes our evening public hearing. Thank you.